the ICC is also, it doesn't have a police force. You know, who is arresting Netanyahu today? Who's arresting Putin?
Sometimes it may take a long time, but never say never.
We found that out with Milosevic, the former Serbian president.
Exactly. The fact that you cannot arrest today doesn't mean that you will not be able to arrest tomorrow.
For decades, the International Criminal Court was seen as dispensing selective justice. All of its cases were African. However, with arrest warrants now issued against Russian President Putin, Israeli Prime Minister Netanyahu, and former Philippines President Duterte, has the ICC begun to fulfill its mandate of being a truly international court? I'm Ken Roth. For 3 decades, I led Human Rights Watch, documenting mass atrocities and pressing for the perpetrators to be brought to justice. On this episode of Reframe, I'm speaking with Judge Silvia Fernandez de Garmendi, one of the founding jurists of the International Criminal Court. Silvia is from Argentina, and she became the ICC's first Latin American and female president. Thank you. Silvia Fernandez, it's wonderful to have you here. You were there at the beginning when the International Criminal Court was really being created. Could you explain its significance? What did we have before that, and what does the ICC signify today?
Well, indeed, I was there from the beginning. I have to say, when it was indeed created in 1998, at the time it was qualified as a revolution. And by some. Today, when we think of that, we think maybe it's an exaggeration. But when we think where we were in '98, we came indeed from an era of impunity, basically. There was nothing almost in terms of justice for 100 years in the 20th century at the national and international level. One of the exceptions was Argentina, with a 1985 the trial to the military juntas in
But they were particularly
Argentina.
discredited because they'd lost the Malvinas-Falkland War.
Yes, but indeed, as a transitional mechanism, when we were going into democracy, there was a big push for justice. Mm-hmm. And it was controversial. Some of the candidates wanted impunity, because impunity was indeed the rule in every other country. When you think of South Africa coming out of the apartheid, they created a Truth and Reconciliation Commission, but it did not go into prosecutions. So at the national level, we were indeed doing something that was exceptional. Mm-hmm. And at the international level, you had, after the Second World War, you have the Nuremberg tribunals, the Tokyo Tribunal, and then nothing for 50 years,
yes.
Until the end of the Cold War, and then 2 tribunals were created by the Security Council for the former Yugoslavia and Rwanda. When the ICC was created, it was the first time that the international community accepted that accountability had to be the rule and not the exception, and not for one situation that was predetermined, but in general. So that's why it was called a revolution.
Mm-hmm. Now, it was, I mean, theoretically universal, mm-hmm. but of course it was limited. For example, you know, the ICC has no jurisdiction over China. Mm-hmm. So could you explain what are the limits? When can the ICC act and when can it not act?
The court was created as with a global aspiration, but it is dependent on who joins this treaty, because it's not based on universal jurisdiction. It's basically based on what is normal in any country, which is territorial jurisdiction, or the country where the crimes are committed needs to be a party to the treaty, or the country or the state or the nationality of the perpetrators. Mm-hmm. So you need these 2 states to be parties to the treaty. That's why the court doesn't have jurisdiction everywhere. It has this global aspiration. 125 states are now state parties to the treaty, which is not insignificant. It's 2/3 of the international community, but we have 70 states more to go to be universal. So.
And of course, the other route was through the UN Security Council,
Exactly.
but then you had to deal with the veto.
The Security Council is recognized, they has the power to ask the court to investigate in a situation, even if the state is not a state party. But of course, the Security Council is a political actor where the 5 permanent members have a veto power, and indeed they had veto in the past some referrals to the court in Syria and in Myanmar.
Now, from the outset, from well before the founding conference in Rome, the U.S. government had a very different vision of this court and was ultimately very opposed to what emerged. Could you explain what the U.S. position was?
Yes. Well, the relationship with the U.S. has been a long, winding, and bumpy road, I have to say. They were in favor of creating the court. So they negotiated in a very positive way towards the creation of the court, but against the Rome Statute, because of the focus of the system on territorial jurisdiction. They said, focusing on territorial jurisdiction, it means that the court eventually will be able to investigate and prosecute non-parties, nationals from the United States. This concern about having investigations or prosecutions for American nationals or their allies and friends has been the underlying concern throughout these 20 years of relationship.
This was the Clinton administration. This was a Democratic administration.
Yeah.
Wanted a court that could never prosecute an American. It strikes me as odd that that was the red line that they drew, because I'm an American. If I walk out on the streets of London and murder somebody, is it an affront to American sovereignty if the British government prosecutes me because I committed a crime on their territory? I mean, obviously not. Why does that change if Britain has conferred this power to the International Criminal Court?
Well, indeed, after the adoption of the Rome Statute, the representatives explicitly said that they could not accept that the court would be able to investigate their soldiers who are posted around the world, defending peace and defending their allies. And they said territorial jurisdiction on the basis of a treaty is illegal because a treaty is supposed to be binding for those who are parties to it. So there was this legalistic approach to it, but also the main concern that they could be investigated for genocide, war crimes, crimes against humanity, and of course aggression now. But they have accepted the Convention on Genocide, and the Convention on Genocide is also based on territorial jurisdiction.
Now, the U.S. attitude toward territorial jurisdiction evolved for a while, didn't it? And I'm thinking about the prosecution of Putin.
The arguments change a little bit, but the underlying concern is always the same. It's the concern about investigations and prosecutions against American nationals or their friends. Mm-hmm. So it's not about the law, but about the target.
Yeah. No, I mean, but it struck me as, obviously completely hypocritical that when Putin was charged, not only did President Biden at that point say this was justified, but the Republican Party endorsed it.
Yeah.
And Lindsey Graham, who is, the South Carolina Republican senator who takes the lead on these issues, pushed through a unanimous resolution supporting the ICC until Netanyahu was charged under the same territorial jurisdiction. And that was the end of that.
Exactly. Again, this is the same problem, friends and allies.
Yes. Now, what do you make of what Trump has now done for the second time, which is to impose sanctions on the ICC prosecutor? First, the prior one, now Karim Khan, for having this audacity to go after an American ally.
Today, I would say the relationship is at the lowest point with these sanctions. Sanctions that could mean freezing of assets or travel bans, but also the threat to impose sanctions to those non-American individuals and corporations that may cooperate with the court. So this is a very serious attempt to hinder cooperation and hinder the work of the court. The first Trump administration imposed sanctions against the former prosecutor.
Because she had the audacity to
investigate in Afghanistan.
Which might have implicated the Bush-era torturers.
Exactly.
But also to open an investigation of Israel.
Yeah, exactly. At the time, the explicit argument was particularly Afghanistan, but now it is indeed because of the investigations in Palestine and the arrest warrants. Yeah.
Now, If we step back, what has the ICC accomplished so far? And are you disappointed with what's been achieved?
I'm not disappointed, but I do hear some disappointment of people, countries that say, well, the court has only managed to have a handful of cases. And what does it mean? But I have to say that, of course, cases are extremely important, and the court has become better at its cases. It has indeed improved the proceedings, shortened the proceedings. These cases are extremely important also for victims. But the court was created as a last resort institution, as a backup to states. So the idea it is indeed that states are the ones that must investigate and prosecute. So, and I think the court has made achievements in, I would say, three main areas. First, it has indeed influenced national systems. Because of the adoption of the treaty and the ICC existence, many states now have adopted legislation that enables them to investigate and prosecute domestically. And many have also established even war crimes units within their systems in order to investigate and prosecute. Second, through its cases and its law, the court has indeed helped to develop the law on international crimes and war crimes, crimes against humanity in particular, and also in the development of the law for sexual and gender-based crimes, which is extremely important. Now, not only rape, but other forms of sexual violence, forced prostitution, forced marriage, sexual slavery. And a third point where I would like to mention is that the court, the ICC system, for the first time, allowed victims to participate in the proceedings and seek reparations. This was a total novelty at the time of the adoption of the treaty, but now it is being replicated in other international and hybrid tribunals in the national systems. So I think this is also a great achievement.
Yeah. Of course, the ICC is also, it doesn't have a police force. You know, who is arresting Netanyahu today? Who's arresting Putin? You know, so the fact that somebody is charged doesn't necessarily mean that they're in the dock.
Absolutely, because the court indeed doesn't have an army, doesn't have a police, doesn't have intelligence services. It depends on the external cooperation to investigate, to prosecute, and to arrest. And it cannot proceed without arrest because the court doesn't have trials in absentia, for instance.
And it shouldn't, yes.
That doesn't mean the arrest warrants, even if they are not executed immediately, they don't mean anything. They're still very impactful.
What is the significance that Putin and Netanyahu have been charged, but they're not yet in custody? Does it matter?
I think it matters a lot. And you can see, first of all, the 125 states are obliged to arrest. That limits the possibility of traveling, of engaging with other states in a normal way, and we've seen how this has impacted in many initiatives that Putin cannot go because he risks being arrested.
He couldn't go to the Pope's funeral.
He couldn't go to the Pope's funeral.
He couldn't go to the BRICS summit in South Africa.
In South Africa and also in Brazil. So this limits the possibility of engaging. Of course, the idea is also it undermines the legitimacy of the person under an arrest warrant. And of course, these crimes have no statute of limitations, and sometimes it may take a long time, but never say never.
We found that out with Milosevic, the former Serbian president.
Exactly.
Yes.
Exactly.
Thought he was president for life, and suddenly he was in The Hague.
Exactly. So the fact that you cannot arrest today doesn't mean that you will not be able to arrest tomorrow.
But it worries me that there's this, persistent Israel exception in the view of some governments.
Well, we live in a real world. I think what has been achieved in 30 years is huge. Justice is a component of international relations and conflict resolution, but it's not the only component. So, and in human rights, it's the same. It's a constant battle to make sure that these ideas and these values are upheld.
Okay, we are going to open it up to questions from the audience now.
The ICC was created at the height of the so-called unipolar moment. It was the height of the United States supremacy. I wanted to ask you if we're moving beyond the US-led orders, a more multipolar order, something that many people see as geopolitically more equitable. Is this good or bad for how international law can proceed in the future and how it can be implemented?
The International Criminal Court was created at a time where certain values were really, we were at the peak of idealism, I would say, after the end of the Cold War. And that is what enabled the establishment of the ad hoc tribunals for former Yugoslavia, Rwanda, and the ICC. The current context where we see an erosion of multilateralism, an erosion of certain values, an erosion of the rule of law, it is not a favorable context, I would say. If we had to create the court today, I don't think we would be able to. And that's why the court now needs not only support and cooperation, but also a lot of protection.
Yeah. If I could add to that, I mean, I think it's important to recognize that the court was created despite the United States, not because of the United States. And the reason it was possible is because 60 small and medium-sized governments, including Argentina, banded together and together had the moral and political clout to stand up to the superpower. And that's what it's going to take today, because we have, with Trump in the White House, somebody who is indifferent to international law. Clearly we have the same thing in Moscow and Beijing, but they were not court supporters then either. So the answer, I think, in terms of the success of the court going forward, is will we see a comparable broad coalition of governments that are willing to stand up for international law? Another question.
We've been talking about states and governments, but one can say that public perception is at an all-time low around international law, not only from the right, but also from the left. People have seen the warrants and the investigations for Gaza and Ukraine, but have seen that nothing has changed on the ground. So my question is, where do we go from here?
Well, I would never give up, as was the recommendation of Ben Ferencz, former prosecutor of Nuremberg. First of all, I don't think the court is very well known yet. And sometimes its work is not very well understood. You talk about selective justice. I think the perception is still of frustration because the court cannot deal with all the situations that are of concern to mankind. Because they don't understand these technicalities of jurisdiction and why is the court doing this and not doing that. So I think the only answer to that is to continue trying to raise awareness about what the court can do and cannot do. The court does a lot in this regard in terms of outreach, in terms of reaching out to the public and to all communities to make the court better understood. But I think also we go back to the role of the court. Sometimes it's not understood as a secondary court, a last resort institution. I think the public perception is, everybody should be at The Hague. Well, that is not going to happen. But I think that's why we all need to be all the time explaining what is the court about. I still think that for victims, the court continues to be a beacon of hope. And you can see in areas where there is, when they're suffering, when they are part of the violence, they do hope for justice and they do hope for the ICC to assist.
I mean, the way I tend to look at this, if we have a crime spree in London, people don't say, criminal law is meaningless. We do have a crime spree globally today between Gaza, Ukraine, Sudan, Eastern Congo, Myanmar. There's some bad cases. The good news in this is that there has been broad condemnation by the UN Human Rights Council. The ICC has acted in many of these cases, and some of them the International Court of Justice. So there's an affirmation of the law, but it's frustrating because these perpetrators so far are getting away with their atrocities. And so I don't know, is the glass half full, half empty at this stage? Where do you think it is?
Well, I think in terms of the world we are living on today, I think for justice, the situation is the glass is half full in a way, because we do seem to have a lot of justice initiatives at a time of so much violence. There is this erosion of multilateralism. the disrespect for the rule of law, but at the same time, we do see the ICJ, the International Court of Justice, the ICC, all these efforts by national systems, they're all trying to do some justice in a very, very difficult context. So I wouldn't say that this situation is in decline. On the contrary, I talked about universal jurisdiction. There is a lot about that. There is this creation of mechanisms to collect the evidence and safeguard for future prosecutions in Myanmar, in Syria. So that shows, that reaffirms this idea that despite of the problems, we continue to believe that justice is part of the answer and that it is needed.
Thank you. Another question from the audience.
In your opinion, how should the Rome Statute evolve to contain new wars, new forms of war crime, for example, cyber operations or psychological manipulation through AI and those types?
Thank you. Indeed, lots has happened in the areas of technology, even in the last 30 years. There are discussions on cyber attacks and cyber war, and some of it may be already covered by the Rome Statute. And the same applies to environmental harm and crimes, and others are discussing other crimes that may be added, like ecocide, slave trade, some crimes that were not included in 1998.
But what would it take to actually add a crime? Well,
that is not very simple, and because it would require an amendment to the Rome Statute, and of course, then the amendment needs to enter into force. You know, there have been already amendments to the Rome Statute with the aggression amendments. So this is a long process, but it's not impossible, and it is being discussed at this point. But also, because it's so difficult to add new crimes through a process of amendments, there is also this, for instance, the Office of the Prosecutor is working on policies to see how they can focus more on environmental harm within the framework that is already there. So both options are open. One is easier than the other.
Let's take one last question.
So I'm a student in the United States, and a lot of people I talk to who might have otherwise been interested in federal careers, for example, are no longer interested in it because of the intimidation the Trump administration has used on federal employees they view as enemies. How are the ICC able to offer protections to people who might be sanctioned by governments who don't like the ICC? Thank you.
The court cannot protect against sanctions. The court, we have the prosecutor that is now under sanctions, and of course there is all a system in order to make sure that he can continue doing its work, but there are no sanctions against everyone at this point. But of course there is a threat for those that cooperate with the institution. And of course, American nationals could be penalized for cooperating with the court under the sanctions regime.
And it's worth noting that it's not just Trump who imposed sanctions, but also the Russian government that is trying to prosecute.
The Russian, indeed, as a response to the arrest warrants against Putin, the Russian Federation instituted criminal proceedings against the prosecutor and judges of the court. That means that the court needs to establish a system to protect them and take all the measures to make sure that they are not arrested.
So maybe to sum up, I mean, it seems that while the court does face significant challenges, it's not only Trump, but it has other governments applying double standards. It has limited jurisdiction. Many governments still have not joined it. There is a lot of lawlessness for it to address, but it still has enormous potential. And if we think about where we've come from, just in our professional lifetimes, from a world where justice was essentially impossible to one where many leaders today are worried about being prosecuted, we've come a long way. And we have a ways to go, but I see mainly potential here.
I think if it is not a revolution, it has been indeed a huge change in the way we have established the concept of accountability as an essential component of international relations. I think this is a huge achievement. And of course, it's not easy. We never thought it would be easy. It has become more difficult at certain times, but it has a huge potential and much has been done already.
Silvia Fernandez, thank you very much for joining us. And thank you to all of you here in the audience for your insightful questions. And thanks to the audience at home as well.